Good afternoon, everyone. My name is Alina Patatanyan, and I'm here from LA County Department of Consumer and Business Affairs. Joining me here today is Filiberto Quintero from U.S. Department of Labor. Together with Filiberto, we will be covering the Family and Medical Leave Act, breakdown for nursing mothers, child labor, the LA County COVID-19 vaccine ordinance, the Los Angeles County minimum wage, we will go briefly about that, and some other protections for workers, especially essential workers. At the conclusion of this webinar, we will be answering any questions you might have, so please submit them through the chat box. Please make sure your microphone is muted. And just to let you know, this webinar will be recorded and will be available on our YouTube page. With this said, I will give the presentation to Filiberto so he can start. Filiberto.
Thank you very much, Alina. And I'm Filiberto from the Department of Labor, Wage and Hour Division, and I'm the Community Outreach and Resource Planning Specialist with them. And I'm here to talk to you about essential workers, essential protections. So just a little bit, right, about essential workers, essential protection. It's got to do a lot with us coming out of this global pandemic. So we want to ensure that the public knows that the Wage and Hour Division is still focused on protecting the workforce and being able to support the essential workers to, continue moving forward in this economy. So I wanted to share a little bit about who we are here in the next slide. And there we go. So we're the ones that are responsible for ensuring the nation's most comprehensive federal laws out there, right? Like the minimum wage, overtime, record keeping, child labor. There's special employment with like we mentioned, there's migrant workers, there's the nursing mothers portions of that. There's also prevailing wage for government service workers and construction contracts, and also like certain temporary work programs. So that's a little bit of what all of our work encompasses in what we do. And we are there to protect the rights, right, of the workers. So we want to make sure that we're helping workers, advocates, employers, all stakeholders understand what the employers' responsibilities are in the protection of those employees, especially during the COVID-19 pandemic. So if we could go to the next slide, please. So one of the key things about us is that we enforce federal law, especially under the Wage and Hour Division, and this is regardless of the immigration status of a person. So we do not look into immigration status, that we protect people regardless of that, and we don't even ask. Like, we want to make sure we stay away from that altogether. So we will not even question immigration status. We want to make sure that anybody that works in the United States, right, or any of our territories, is comfortable to talk to us about any issue they may be having where their rights are being violated. So we want to make sure that they are comfortable. So I want to make it very clear that we will speak to everybody and enforce the law equally for everybody, regardless of immigration status. All right. So for the next slide here, please. So the way we do this, right, we have a little bit, we have offices throughout the country, right? So we want to make sure that the goal is really to be able to hear from you and to give you the information about the worker rights and make sure that you understand them and you have that as a resource to be able to reach out for us, have that comfort. We also want to continue, right, uninterrupted investigations, on-site enforcement, different things we do, which I'll go over in a little bit here, and also continue these educational opportunities. The outreach activities like these are very important in what we do, to reach out to people, give you information, and be able to educate you on what those rights are that you should be adhering to, or people should be protected by. So that is one of the main things that we do, and you can see on this map, right? We do it all across the country. We have our national number there, and you can see it on the bottom right of this slide. Also has our website and national number. And I'll be also providing our local number here towards the end of this presentation that I'm doing. So if you have a pen and paper handy, or if you don't, if you want to go grab one to to be ready by the end of this presentation. I'll be sharing some websites and also phone numbers that may be useful. But these numbers will be repeated at the bottom right of the page, right, to be able to get that help. You can see we have offices throughout the country, some areas more than others, to be able to reach as many workers as we can, as many employers as we can, and all these groups that we try to work with. You could go to the next slide, please. So what is it that we do, right? Well, our main mission is to promote and achieve compliance with labor standards and to protect and enhance the welfare of the nation's workforce. So how do we achieve this is one of the key things, right? Well, we achieve it by going and conducting investigations, which is the most common thing people know about us. And those can be investigations that we do in cases where there is a complaint about a particular situation that may be with one of our laws. It could also be from directed investigations, which means that we'll physically just go out to an employer site without a complaint being there and conduct investigations. And we do this strategically. We try to go out there and help out, you know, in areas that we feel that there's a stronger need, right? Where there's low-wage workers or people have a tendency not to complain as much. So we try to go there in those type of communities. So we do that through directed investigations. We also, as you can see, do many other things. Outreach to workers, outreach to, or education here, it says for employers, but in the same way, we do outreach to employers. We do that in order to ensure that you know your rights as a worker. And if it's not to memorize it, right? I'm going to talk about a lot of things here. I'm going to give you a lot of information. It's impossible to memorize it, but hopefully you remember, hey, that guy was talking about something about family leave, something about nursing mothers. Maybe we'll reach out to them and you have this number handy or this website to be able to do it. And the same thing with employers. Oh, how do I do this? How do I make sure that I'm complying with the law? I kind of remember that guy talking about family medical leave. Maybe I'll reach out with him as well. So there's the reason we do these outreaches, not for you to have to memorize all this information, but to know where to go as a source. And another thing we do is also have these partnerships like we have with the LA County, right? We come out here and we conduct these joint outreaches together to be able to inform the public. And we do this with other nonprofit organizations as well. And other agencies, we go to chambers of commerce and that type of thing. So if we go to the next slide, please. So how do we do this, right? How do we serve the workers? How do we serve the employers? And the way we do this is through focusing on the sectors where the data is showing us there's high violations, right? And the wages are low. And with the employers, through enforcing and leveling the playing field for those employers to make sure all of the employers are playing by the same rules and not one employer having advantage over the other. Now we also are focusing on essential workers in these cases. As you can see here, there's a large listing of different you know, areas where essential workers work. We're maybe missing some. I could already tell we don't have garment in there as one of the essential worker listing. Excuse me, but you can see there's many industries out there where people are working still, right? Where these essential workers through the pandemic, they were still working, and there's a high violation rate possibility out there, and the possibility of people complaining may be low in those cases. So we'll go ahead and go to the next slide. So you can see some of the risks that we see for these essential workers is that they may be paid low wages, right? They may be, you know, below the federal minimum wage, or they may be low, whatever the case may be, right? They may have low wages. They're working off the clock, right? Clocking out and continuing to working, or working before clocking in, working through their lunches and not being paid for that hour or whatever time that may be. Working as a independent contractor, right? Being misclassified as that when they're truly an employer. There's different rules, or an employee, sorry. There's different rules there. But they're also, you know, there's a lot of hazards out there. There's heat, you know, there's the COVID, there's a lot of other hazards out there so that they're exposing themselves as well. And they're also denied qualified leave, which we lead into like Family Medical Leave Act and that type of thing. So the denial of this leave is important. I'll talk a little bit about that as well. We can go on to the next slide, please. So the first act that I'll be talking briefly about is actually the Fair Labor Standards Act, which is the most common one. If you go on to the next slide, most common of our acts that we have. is this act. And it's the one that you know most about, right? We would protect minimum wage, overtime, record keeping, youth employment, and try to have employers not retaliate. Now, the big surprise there for everybody is always that minimum wage, right? So the minimum wage on there's a $7.25 per hour, and yes, that is our current minimum wage. It's been in effect since 2009. And that is national. We know that states usually have stricter, and I'll say for counties and cities. So, you know, the requirement for the employer is always to go by the strictest of the laws, right? The one that's going to benefit the employee the most. But in our case, our minimum wage enforcement is at $7.25 per hour. All right. Now, what the FLSA does not require, that you won't see listed here, is we don't require the employer to provide vacation or holidays, severance or sick pay, right? Or even provide rest periods or holidays off. So these are not required under federal law, but you can see that there is state laws and local laws that may require that, right? There may be rest periods and meal periods required under those type of laws. So there's a little bit about the FLSA. Don't want to touch too much because I'm sure you've heard a lot about this particular law, but a little bit more about what this law covers that you may not hear. If we can go on in the next slide, please. Is about child labor, right? So a lot of people are not too sure about what it means, what child labor means. It doesn't mean that a child cannot work, right? A child is anybody that's working in a non-agriculture job that's under the age of 18. So 17 and under is considered a child in the non-agriculture world. And so in that doesn't mean they cannot work. That means that they have to follow certain rules, right? So we see the minimum age of employment to be working at all is 14 years of age, with some exceptions out there, right? Newspaper delivery, childcare, things of that sort. There's some actors, right? They work out there. So there's some exceptions to it. You know, we have those exceptions available if you want to find out more, where we can answer those questions. But there's, for the 14 and 15-year-olds, you can see there's a lot stricter restrictions than you will see for the 16 and 17-year-olds. They're more restricted in hours and the type of things where they can do, where 16 and 17-year-olds are pretty wide open on what they can do, as long as they're not in one of the hazardous occupations that are prohibited under the law, which is like working on roofs or about roofs for roofing, right? Or, you know, operating forklifts, you know, driving as part of their work. So these are some things that we see that child labor people may not be aware of, but this is a little bit about what the Fair Labor Standards does as well. Child labor protections. Another thing that they also do under the FLSA, in the next slide, please, is rest time for nursing mothers, right? Break time for nursing mothers is a part of the Fair Labor Standards Act. You can see there it's part of Section 7 of the Fair Labor Standards Act. So what this law does is it provides up to 1 year of the of protection for the mother to be able to take breaks to express milk in a place that is a place that she can go where it's private, where it's, you know, she has the proper accessible things to be able to express milk, and is not a bathroom, which is very key in this one, right? A lot of times we see, unfortunately, that bathrooms are used to provide the space. It has to be a space other than a bathroom. So there's a very important law, right? This coming August is going to be Nursing Mothers Awareness Week. So this, or Breastfeeding Awareness Month, sorry. And so this is a big law during that month that we try to really, promote. And so we're getting ahead of it a little bit right here. But this is one of the portions of that law. So this is for the first year after the child's birth, where the mother has this right to be able to take these breaks as needed. That doesn't mean that she has to wait for her lunch, doesn't mean she has to wait for her break after 2 or 3 hours. If she needs to express milk after being at work just a half hour or an hour, whatever the time may be, it's important that she gets those breaks, because there can be some very bad medical side effects where she stops producing milk and the child then does not get that benefit. So it's extremely important that they get these breaks. So there are some rules around it. Again, we can very much clarify more if you want to reach out to us. We could clarify more about this law, portion of the law, sorry. Next slide, please. As I spoke about before, and also Alina mentioned, we also enforce the Family and Medical Leave Act. All right, the Family and Medical Leave Act is one of the more important acts that we also enforce, very common. And we'll go ahead and go to the next slide to talk about it. So this act provides 12 weeks, right, 12 work weeks of unpaid leave per FMLA qualifying year, right? And during those 12 weeks, your job is protected to where you can come back to the same or equivalent position, so long as you're not considered like a key employee. There's some minor exceptions. You want to, it's got to be make sure that you're covered under the law, that the employer is covered, and that you meet certain eligibilities. But that gives you job protection. It protects the benefits, right, when you're on leave, so your benefits continue. You're not losing those benefits, right? Especially those health benefits are extremely important, right? And oh, it already says it down there, return to the same or equivalent position, part of what the job protection does, right? So this is a very important law. There's some people that need to take that leave, even for COVID-19. And yes, COVID-19 may be a qualifying reason. That's something that's determined, of course, by a doctor. When the doctor, does the medical examination, they can determine that it is FMLA qualifying at that time. It is not determined by us. There's certain steps there with the medical certification. But yes, this is part of it. It's also FMLA can apply for the birth of a child, right? You hear about baby bonding time and that type of thing. Well, there is these 12 weeks of protection for use for up to the first year of the child's birth, or placement of a child, right, from adoption, that type of thing. There's a lot to this law, and it applies also if you have to take leave, not just for yourself, but for your spouse, for your mother, your father, and for your children, right? This applies for those. There's certain rules when it comes to adult children, but still there's some benefits that can apply there depending on that. So this is what this law protects. Very important that we protect this leave to ensure that people are getting the proper medical break. Next slide, please. Family First Coronavirus Response Act. I'm sure you guys heard about this act last year. It went into effect on April 1st, 2020. It stopped going into effect on December 1st of 2020, which just happened last December. That means that this is the only period that it was in effect where you can take up to 2 weeks of paid leave by the employer if you work with an employer that had like less than 500 employees. This is the federal law that we would enforce. Now, if it's not in effect now as of January 1st forward, but if there was a violation that occurred between April 1st and December 31st, you still can place a complaint if they did not, pay you the required leave under the the Family First Coronavirus Response Act. And that you can, again, reach out to us and we'll look at that situation. And that's for taking leave during the time that you may have needed that time between April 1st and December 31st, when you weren't able to work, when there was work available. That's very key. Now, if the worker doesn't have work happening and doesn't have a job for you to perform, this law doesn't apply. It's only when they needed you to work and you couldn't work and weren't available due to one of the COVID-19 qualifying reasons. Okay, we'll go ahead and move on to the next slide. Okay, and so how can we help? This is one of the things that we really want to make sure people know. For workers, the way that we can help them is if they have questions, they can call us, right? If the employer has violated their workplace right, you reach out to us. We can help the employees in that situation. And we don't care if you want to place a complaint or not at the moment. If you just have questions, it's fine. You don't have to call from a number. You can call from private numbers. You can use a false name if you don't feel comfortable, right? It doesn't matter. It's same for employers. We're there to be able to be called confidentially, to be able to learn about your legal responsibilities, ensure you're operating in compliance under the law. This is a very important thing. Now, I know it's in the complaint slide, but this is how we can help the employees and employers is through that, right? Is to make sure, and again, I can't emphasize enough, we don't care who it is on the other end, we'll answer your questions, even if it's John Doe calling us, right? With questions from a private number or from a phone booth somewhere, if they still exist. It does not matter to us. Please call us, ask the questions to help your business, to help you as a worker. We want to make sure that everybody is in compliance and help them out and what steps they may take from there. The decision to put in a complaint or to make changes is going to be up to you. Now, how do you file a complaint? It can be submitted by phone, like I mentioned. They can be submitted by third parties. So if there's somebody that has enough information, right, like a spouse or even like nonprofit organizations that sometimes put them in, they can, of course, they are confidential. They can be also submitted. It mentions again, it doesn't ask about the worker's status, and you do not pay anything to file a complaint. So these can come from many different issues. It can even come from, if we go on to the next slide, I think it goes over a little bit more. who, right? It can be employees, like I mentioned, current and former. If you were a former employee, it doesn't mean you can't place a complaint. This law can cover you because the statute of limitations can run for like 2 years after you were employed, maybe even 3, depending on the law. So you may still be able to place that complaint. A parent and guardian, right? If they have enough information. School officials, that's a new one for me that I didn't remember off the top of my head. I'm glad I'm reading it. But school officials, right? They learn about children that are working maybe in hazardous occupations out there. Other employers, this is where I was saying, leveling the playing field. If you see an employer that's competing against another employer, and one employer is not adhering to overtime law and the other is, naturally they're going to have an advantage because they're not paying properly. So employers that don't feel that they have a level playing field and wish to complain about the other employers that are cheating the system, or they feel they're cheating the system, then they can complain as well. Advocacy groups can also complain, and then agencies, much like right now we're sharing right now with the with the LA County, right? So they would be able to also place complaints with us if they see that there's something out there. Next slide, please. And then what happens, right? What happens once we do an investigation and maybe there's employees out there that are owed money, right? There's money that could be owed back wages, and you don't know. You may remember a investigation that we were there. You may hear from ex-workers or co-workers currently that there was an investigation and people are owed money from working during a particular period of time. Well, to relieve you of any doubt, this is where the pen and paper comes in, right? There is a part of our website that we call the Workers Owed Wages. This is one of our resources. It's at www.dol.gov/WOW. That's the WOW, right? Workers Owed Wages. So this is where the workers can go in, they put in the employer information and their information. They try to find out if that employer paid the back wages and they are due any back wages from that employer. This is where you can find out the conclusion of those investigations that we do conduct and any monies that may be owed to you. You hear this a lot, right? Where, oh, the government owes you money. Well, this is one of those places where the government can owe you money, right? We may be holding money for you, and they don't hold it forever. There's only a certain amount of time before that then goes into the general fund. I don't remember the number of years, but I wouldn't risk it. As soon as you find out, I'd go in here and check, or call us and we'd be happy to check for you as well. Next slide, please. And another set of online resources we have on our website that you see down in the bottom right corner, right? The dol.gov/agencies/WHD. We also have resources called workers.gov and employer.gov. I think you could place them in there just like that, worker.gov and employer.gov, and I'll take you to these. And this gives you a lot of resources that I've talked about already, right, on the different laws. You can find them under these two different websites. One has more of a focus naturally on employees, the other one on employers. It's there for both. We are a neutral party in this situation. We do not advocate either side. We are there for information and to ensure compliance. So that's what these resources are out there for, to ensure that you're getting the information to be compliant as an employer, or to ensure that you're not violated, your rights are not violated as a worker. So please write these ones down, and if not, at least the website at the bottom will have it. And then the last slide here for me is the next one, besides maybe a disclaimer at the end, which I'll go over. But this is our contact information, as I mentioned before. This is the website, www.dol.gov/agencies/WHD for the wage and hour division. This is where you'll be able to reach us and be able to see the different sites, find a local office if you don't happen to be in our office in our district. It doesn't matter, even if you're not, you could still call us, right? There's also the 866 number, right? 866 for US wage, or for the numbers 1-866-487-9243. You can also call that number. They'll direct you also. They'll be able to help answer questions. And our local number, where I'd be the most happy if you call, our local office, that's at the 626 area code 966-0478. This is the number I like to repeat a lot. So 626-966-0478. That is our West Covina district office. Happens to be my district office. And even if you're not within our district, we don't mind answering those questions and being able to help direct you in the correct way, right? So this is our district office there. The next slide is going to be a disclaimer. If I just want to make sure that this is for informational purposes only, right? It does not carry any legal opinion. So we're providing this to the public as a service, a free service. Like we mentioned, this is all free to the public. And if you want to know the actual legal verbiage of it, you can look under the Federal Register or the Code of Federal Regulations when it comes to all of those particular laws. Sorry I rushed through all of this, but I know we're trying to get through so we can get some questions for everybody. I hope this was informative. And I'm going to go ahead and hand it back to you, Elisa. Thank you so much.
Thank you so much, Filiberto. Great information. Hi, everybody again. Now I will go over some of the laws, some of the ordinances that over here locally in LA County we have and the CBA enforces. First, I want to talk about one of the recent ordinances. It's an urgency and temporary ordinance called Employee Paid Leave for Expanded COVID-19 Vaccine Access Ordinance. So this is an urgency ordinance that requires private employers in the unincorporated areas of the county to provide paid leave for employees to receive COVID-19 vaccine injections. We want to see, if you can see the unincorporated where we have it highlighted, so it's important to make sure that you as an employee have to be working in the unincorporated areas of the county to be able to qualify for these hours. Effective dates of this ordinance is from January 1st, 2021 through August 31st, 2021, unless otherwise it'll be extended. Next slide. So what are the, who does this ordinance apply to? Applicability. So you as an employee must be a full-time or part-time employee. If as an employee you qualify to receive paid leave hours under Labor Code Section 248.2, that first you have to exhaust all of those hours, which are 80 hours under this Labor Code section, in order to qualify for these extra hours. Also, one of the requirements is that upon request, your employer may ask for the verification that you received the COVID-19 vaccination. Next slide, please. So how many hours of paid leave you are allowed under this ordinance? So as a full-time employee, you are given 4 hours per injection. So if you receive 2 injections, you will be entitled to 8 hours of paid leave hours. Part-time employees are given prorated amount of the 4 hours based on their normally scheduled work hours over the 2 weeks preceding the injections. For example, if they work 10 hours in that 2-week period, they will be given 1 hour of paid leave. As for the amount that you will get paid when you take this leave, it's at your normal rate of pay. Next slide. Some of the additional requirements that this ordinance has, that employers must display a poster. So this ordinance requires that employers post a poster made and available by the CBA. It's available on our website, where employers have to post in a conspicuous place where all employees can see to know what they are entitled to and know their rights under this ordinance. Employer must keep and allow access to accurate and complete payroll records for at least 4 years in order for the CBA to investigate cases. Retaliation is prohibited. This means that if you ask for this paid leave hours to go and get an ejection and any change occurs at your workplace, you get retaliated, you get fired, your hours get cut, you are protected under this ordinance. We will take a complaint and investigate. Employee has a right of action, private right of action, which means that if your employer does not provide you these hours that you're entitled under this ordinance, you can file a lawsuit in the Superior Court. But also the CBA has the authority to investigate complaints of alleged violation of this ordinance. This wraps up this ordinance. If you have any questions, please go ahead and put it in the chat box if you have any questions about the vaccine ordinance. Now I will briefly touch on some other ordinances that over here at the CBA we enforce. I just wanted to let everybody know, remind everybody that this July 1st, the minimum wage for small businesses was increased to $15 from $14.25 to $15. As you can see on this chart, currently large businesses and small businesses lined up, and we are at $15. The next increase will happen next July 1st, 2022, and it'll go up based on the consumer price index, based on the CPI. Next slide. On your screen, you're seeing the LA County minimum wage poster. Employers are required to post this in a conspicuous place at a job located in the unincorporated areas of the county. The poster is available on our website. If you are an employee and you work in the unincorporated area, you don't see this poster posted in a place where you can see, then you can call our 1-800 number and let us know. Next slide. Determining jurisdiction. As I mentioned, the county minimum wage ordinance and the vaccine ordinance, it only applies to unincorporated parts of LA County. That is why it is very important to check jurisdiction, to check whether the address where you work at belongs to unincorporated LA County. Over here, we have 3 links. If I can ask Kevin if he can put the links in the chat box. This is where you want to go again in order to check your job location where you perform work to see if it is unincorporated, to find out whether you qualify for this benefit. Next slide. Santa Monica minimum wage. So at Department of Consumer and Business Affairs, also we have the authority to investigate Santa Monica's minimum wage ordinance. Santa Monica's minimum wage ordinance, as the same as county's minimum wage ordinance for small businesses, was increased to $15 this July 1st, and they line up with large businesses. Again, for them, the next increase will happen next July 1st. It'll go based on the consumer price index, CPI. Next slide. Santa Monica also has a hotel minimum wage provision in their ordinance. A hotel worker is any individual whose primary place of employment is at a hotel and employed by either the hotel directly or someone in contract with the hotel employer. Currently, the Santa Monica hotel minimum wage is $17.64. It went up this July 1st, 2021. Next increase will happen July 1st, 2022, and it'll go. It'll be raised based on the consumer price index. Next. Santa Monica has also a paid sick leave provision in their ordinance. This means that anybody who works in the city of Santa Monica are entitled to paid sick leave hours. Employers with 26 or more employees must provide 72 hours of sick hours to their employees, and employers with 25 or fewer employees are required to provide 40 hours of paid sick leave hours. The employer can choose to accrue paid sick leave instead of front loading in the beginning the 72 or 40 hours. And then the accrual, every 30 hours work, employees are entitled to receive 1 hour of paid sick time. Next. Briefly, I want to mention about another urgency ordinance that became effective during this pandemic. It's the retaliation, which says that retaliation against workers is prohibited. So during the COVID-19 pandemic, the health officer issued a lot of health orders. And when employers would not follow those orders and employees would complain, then they would be retaliated against. They would be fired, their hours would be reduced. So this ordinance protects those workers. So no employer may discriminate in any manner or take adverse action against an employee if they report or discuss their employer's non-compliance with the health officer order, if they belong to the Public Health Council, inform any worker of their rights, or exercise their rights under this ordinance. And the CBA has the authority to investigate. So if you experience this, if you were retaliated because your employer did not follow the health officer orders, whether it was COVID-19 or other related health officer orders, then you can contact our department and we will do an investigation. Next slide. Last but not least, I want to mention about our Hero Pay ordinance. And the Hero Pay became effective on February 26, 2021, and it expired on June 25, 2021. This does not mean that the CBA will not investigate. If someone was entitled to receive Hero Pay during this period from February 26 to June 25, we can still take a complaint and investigate any Hero Pay violation. Hero Pay ordinance applies to grocery or drug retail store that sell primarily food or household goods or prescription or non-prescription medication. Or the store can be 85,000 square feet and dedicate 10% or more of its sales floor to groceries or to food. And on top of all these requirements, the store must be in the unincorporated area of the county. They have to be either publicly traded or have 300 employees nationwide. And they must employ more than 10 employees per store. Based on these requirements, I want to say bring an example of few of the store that this applies to. It doesn't apply to small businesses. It usually applies to big supermarket, big drugstores such as the CVS, Walgreens, Vons, Ross, Target, places like that. Next slide. The requirements of the Hero Pay say that the Hero Pay amount should be at $5 per hour in addition to the employee's base wage. Employees may elect to receive paid leave instead of the Hero Pay amount. There's also a posting requirement for this ordinance. There's a Hero Pay poster available on our website where all employers must post in a conspicuous place. And another requirement is that during this period of time, employers must include information about the Hero Pay on a pay statement, including their hourly rate, the amount of the Hero Pay, and the number of hours worked towards the Hero Pay. Next slide. And here's our contact information. If you have any questions or you need to file a complaint, you can reach us at our 1-800 number. You can go to our website and file an online complaint or email us. We do take anonymous complaints, and like Filiberto said, we will not ask for your immigration status. Third parties can file a complaint. Again, anonymous, we can take anonymous complaint. Your name does not have to be disclosed. 1-800-593-8222 is our toll-free number. Website dcba.lacounty.gov, and you can email us at wagehelp@dcba.lacounty.gov. Thank you everyone for being here today. And now I will go ask Kevin if we have received any questions at this time.
Okay, thank you to Elena and Filiberto. We've received a couple of questions, and if anyone has any additional questions, we encourage you to please type those in the chat box right now. The first question that we received asks, does FMLA also cover the birth of a grandchild?
Oh, excellent question. So when it comes to the coverage, like I mentioned, it's the parent, the spouse, and the children that are covered under FMLA. Grandparents and grandchildren are not covered under FMLA. So if the grandparent wants to take leave for the birth of a grandchild, it would not be allowed. However, if a person is standing what we call in local parentis, so if that grandparent is actually standing in as a parent to that child, they're found in local parentis. There's a special rule out there for people that stand in local parentis, if they're considered the parent, where they can take FMLA, because then technically that is the parent of that child in that situation. So it would depend on that. There is some verbiage in our law regarding in local parentis when it comes to that relationship. So it would really depend on that relationship. But if it's just strictly a grandparent taking leave because of the grandchild, and there's already parents involved in the situation, then that answer would be no.
Okay, great, thank you. Next up, we had more of a comment, but I think maybe we can address it as a question. So someone mentioned, one of our attendees mentioned that they do a lot of work off the clock during lunch breaks and normal breaks as given. It's authorized, and they never complained. They kind of felt that it was being a good member of the team. So how could they possibly address that if that's perhaps, you know, if it's kind of forced or coerced or what have you? What sort of rights do workers have if they're encouraged or pushed to do work on their lunch breaks or their regular breaks?
Okay, I can help field a little bit of that. Now, like I mentioned before, we don't enforce that they have to be given lunch breaks or breaks in general, right? But if they have to work through their breaks or through their lunches, then they need to be paid accordingly, right? It's considered hours worked. So in those cases, yes, they must be recorded correctly. There's record keeping violations possible if they're not being recorded correctly. So they're actually working and they're not, you know, showing them as working on the clock. And it can lead into overtime violations as well, right? It could take you over 40 hours in a work week, and there could be overtime due. So there is a requirement for them to accurately demonstrate the record, right? Demonstrate that they are recording the hours correctly. That is a requirement under the law, and not something that, you know, that necessarily can just be waived. So even if you're being a good team player, it's still considered a violation of the law. So if it turns around and people place a complaint, then we would still be looking into that situation. And you know, we go ask questions, look at records, and hopefully be able to help correct that situation.
Okay, thank you. Our next question is in regards to the LA County Vaccine Paid Leave Ordinance. And the question is stated, are employees required to use sick time and or vacation time prior to this additional paid sick leave?
They're not. If it's regular sick time or their vacation time, they're not required to use those hours. The only hours they are required to use, it's that Labor Code 248.2, the 80 hours, COVID hours that they get under the state law. First, they have to use those hours so they can be entitled to this vaccine ordinance. But other than that, if it's just regular, those 3 days that the state provides them or their vacation time, they're not required to use them.
Okay, great. Our next question is, should exempt employees be paid hourly when forced to perform other types of duties?
I mean, in LA County, we do not enforce, we don't have a law, we don't enforce for the exempt employees. That's something they would need to contact the state to find out what the law is in regards to that.
We do have some verbiage on exemptions, right, under the Code of Federal Regulations 541. We do enforce when it comes to what's considered exempt employees. Now, when they're performing non-exempt work, that would be kind of like we'd have to look at those more of a case-by-case basis. I think that would be something that we would need to get more information on. So I would encourage you to call and find out where we can look at the specific situation there. Just because people are performing like a manager, right? They could be helping perform like in a restaurant. They can help maybe with part of the process, right? Where they're putting out food or that type of thing. Doesn't necessarily lose that exemption. It was all in the duties. So it's just making sure they're meeting the duties that are required under the Code of Federal Regulations. That would keep that employer exempt. That is the key. So with more clarification on that, please give us a call and we would be able to clarify that a lot further in your specific situation.
Okay, thank you for those answers. Our next question is, what are the requirements for premium pay for missed meal and rest breaks?
So as I mentioned before, there is not a requirement for that under federal law. So the Wage and Hour Division would not enforce that. I believe those would be either state or local law. I'm not sure if you would under county, but I think that it's more of a state requirement.
Okay, thank you. Our next question again is COVID related here. My employer requires all employees to take their temperature related to COVID-19 before entering the job site. So do I need to be paid for the time spent taking my temperature?
Okay, so in a situation where an employer requires an employee to get the temperature, then that would be considered part of what needs to happen for your job, right? So if you're a nurse, for example, you got to take a temperature before you start working at the hospital, then your time begins at the time that that requirement begins. So yes, those would be considered hours worked in that situation. The nurse had to take a temperature for her job, right? So this is something that that we do see. It's also with other requirements when they require other things before work, but this is something that happened more frequently nowadays, right? Where people were requiring the temperature checks at the beginning of the workday. So that would be considered the beginning of your workday because it's considered hours worked from that moment forward. Yes, it's required for employment.
Okay, thank you. Our next question is in regards to the LA County Hero Pay ordinance. So the question is, how do you check if your company should have paid Hero Pay?
Well, you can call our number, our 1-800 number, and our counselors can answer you and ask you the questions necessary to determine whether you are entitled to the Hero Pay or not. First of all, your job site need to be located in the unincorporated area of the county. They must be selling food or drugs. They have to be either publicly traded or have 300 employees nationwide. So these are the questions that we are going to ask you to determine if you are entitled to receive the Hero Pay or not. So if you can, again, call our 800 number or you can email us, HeroPay@dcba.lacounty.gov, and we'll be happy to help you. Or wagehelp@dcba.lacounty.gov, any of those websites, emails.
Okay, Elena, it looks like okay, maybe there's one more question that just came in, and again, thank you everyone for your questions. We're getting close to time here, so please get your questions in if you want to get an answer from our presenters. One more question here. Can an employer require all employees to get vaccinated?
As of right now, we don't think that there is a requirement, mandatory requirement to get the COVID-19 vaccination, but they may. We see that there are employers out there that ask for their employees to be vaccinated.
Okay, and there's nothing on the federal end there, Filiberto?
Correct. We don't enforce into the Wage and Hour Division the requirement of the COVID. No, there would not be any enforcement there.
Okay, I think we might have one more question here. Okay, I think it's a long one here. Okay, so this question states, if an employee gets hurt on the job and filled out the required forms, their supervisor asked them, let's see. Sorry, it's a complicated question. I'm trying to make a little bit of sense of it so it can be a little bit more general advice. So it looks like if an employee is hurt on the job and they're filling out the required forms and maybe they're not getting the sort of feedback that they need or that they expect from their supervisors or from their HR department, I guess what sort of steps might they then take if they need to take it, I guess, outside of the workplace?
I don't think I'm understanding the question. I'm sorry.
Sure. An employee was hurt on the job and they're stating that they filled out the required forms to their HR department, but it looks like they're not getting the sort of feedback that they should, that that's not being responded properly to. So what sort of steps might they take in that sort of situation?
Okay, and if it's something that could be FMLA qualifying, there are requirements for responses by employers that they must do it within a certain amount of time from being notified. So if they are not getting that response, then they may be something that they can call us about. If they say that they're covered under FMLA and we say that they're eligible, then there could be something we can look into to help them with. So there could be an FMLA investigation in those situations possible. But again, it depends on the details, and I definitely don't want to say yes or no right here, right? But if we get the very, very specific details, and we would have a lot of questions for that, we'd be able to make that better determination. But it is possible, just off the top of my head with that particular situation.
Okay, thank you. Another question in regards to vaccinations. So can an employer keep an employee home because they are the only employee in the office that is not vaccinated? And would they have to, can they do that with or without pay?
I think we need to get more information on that, Kevin.
Yeah, I think that's perfectly good. And we have the email address right there on the screen for you. So that's wagehelp@dcba.lacounty.gov. I guess something to keep in mind with these LA County ordinances that we're talking about, particularly involving vaccinations. Things are changing very quickly. Rapid changes, more information coming from the Board of Supervisors. So we're more than glad to do some investigation and look into some of these questions, particularly in regards to vaccinations, as obviously that's a new area with lots of changing rules. And along those same lines, another question here. Is there a guideline for an employee who is tested positive for COVID? Is there a guideline in regards to how much they have to quarantine?
Those are more of, I would say that public health questions, Kevin, but we'll be happy to get the answers to those questions if people want to email us with their questions, and so we can get details and we can contact the public health. But in our department at this time, we wouldn't be able to answer that right now. We would need to do more investigation on that.
Yeah, that's a good suggestion for business protocols that aren't necessarily related to pay. Then we would encourage you to look to the LA County Department of Public Health. Their main website, I believe, is at vaccinated.lacounty.gov, or just Google search for LA County Public Health, and there are a whole host of business protocols for a lot of the different businesses here in LA County. So I think that that brings us to the end of our questions, Elena. If anyone else, if we didn't have time to get to your question, or we kind of chose not to answer it because it's a little bit too specific, or you know, we want to do some more investigation on it or get some more details to make sure we get the right answer for you, then we encourage you to email us at wagehelp.dcba or wagehelp@dcba.lacounty.gov. So Elena, I'll hand it back to you to wrap it up.
And thank you, Kevin. Just wanted to say thank you for everybody being here, listening to our presentation. I hope this was informative, helpful to all of you. We are here anytime. You can email us at wagehelp@dcba.lacounty.gov, or for DOL, you can contact Filiberto at the Department of Labor, and we'll be happy to help you with anything we can. Thank you, and have a great afternoon, everyone.